A federal judge in Chicago has temporarily blocked the deployment of hundreds of National Guard soldiers into the state of Illinois. Dramatic legal rebuke to a federal effort that had already put troops on the ground. The order came from U.S. District Judge April Perry, who told the court that letting Guard troops operate in the state right now would do more harm than good, that it would add fuel to the fire. Her decision follows a wave of litigation and public protest tied to the administration's aggressive immigration enforcement actions. City and state officials had filed suit earlier in the week to stop the deployments. Chicago and the state of Illinois argued the presence of federal troops, uninvited by local leaders, risked inflaming tensions around already volatile immigration facilities and protests. At the time the judge heard arguments, some Guard members, including forces from Texas, were already stationed at a federal immigration building in the Chicago suburb of Broadview. Judge Perry noted she had difficulty giving credence to the government's assertions that violence at the Broadview facility justified bringing in soldiers. Her ruling came the same day another judge in Chicago temporarily limited federal officers' ability to disperse crowds, an order brought by protesters and journalists who said they had been injured by federal agents. Taken together, the court actions reflect mounting judicial skepticism about the federal government's characterization of events on the ground. The deployments were part of a broader, high-profile crackdown on immigration announced by the White House, an enforcement push framed by administration officials as necessary to remove what they describe as waves of criminal foreign nationals. The administration defended the troop presence as needed to protect immigration agents and facilities. Critics say the president and his aides have exaggerated the level of danger and have instead sparked civil unrest. Tensions escalated this week after armed troops from Texas arrived to bolster operations in Illinois. In public comments, the president suggested he might even invoke the Insurrection Act, a rarely used law that allows a U.S. president to federalize the military or National Guard to restore order if courts or local officials impeded deployments. The statute's history is fraught. The last major invocation came in 1992 during the Los Angeles unrest. Legal fights over troop deployments are not limited to Illinois. Days earlier, a federal judge temporarily blocked a similar deployment in Portland, Oregon, and an appeals court in San Francisco was reviewing that order. A three-judge panel appeared likely to set aside the Portland blockade, a move that could open the door for more soldiers to be sent to U.S. cities. The judiciary is moving quickly, and each ruling has the potential to shape how and whether military forces are used domestically in the weeks ahead. Back in Chicago, local leaders framed their lawsuit as a defense of municipal authority and civil liberties. They argued that federal agents and troops operating without local consent threaten First Amendment protections, public safety, and the ability of city services to function. Protesters outside the Broadview facility and journalists who covered the scenes have reported being pushed, shoved, or otherwise harmed by federal personnel. Allegations that fed into the judge's concerns. From the federal government's perspective, officials insisted that deployments were limited and focused on protecting people and property. They described the situation at immigration sites as tense and claimed there had been episodes of violence that required additional security. But during the hearing, the court said the record before it did not substantiate the dramatic depiction offered by the government. That credibility gap played a central role in the judge's decision. The political context is impossible to ignore. This enforcement drive has been a signature promise of the president's campaign to use federal power to detain and deport large numbers of migrants, and the administration has argued it will not be deterred by local resistance. The president also publicly called for the jailing of Democratic officials in Illinois, who he said were obstructing the effort. Those comments further inflamed an already combustible atmosphere and were cited by opponents as evidence the federal response risks politicizing public safety. Civil rights advocates and immigrant groups view the legal victories as crucial checks on executive overreach. They say deploying troops to assist immigration enforcement blurs the line between civilian policing and military action, and sets dangerous precedents for how federal power can be used in domestic policy disputes. For many residents and activists on the ground, the court's interventions have offered at least a temporary restraint on a policy they see as punitive and reckless. As the story unfolds, several practical questions now face officials at every level. Who will enforce the order if federal agents are barred from certain tactics? How will immigration facilities operate without additional protection? And what safeguards will be put in place to protect protesters and journalists? Will appeals courts overturn the temporary blocks, or will judges continue to put limits on deployments? The answers will determine whether the current pattern of confrontation eases or escalates. For residents near Broadview and in other cities targeted for heightened enforcement, the immediate reality is uncertainty. Families who live near the facilities have watched armed personnel arrive and feared for their neighborhoods. Protesters show up daily demanding transparency and restraint. Journalists covering the actions have faced risks while trying to document events in real time. Against this backdrop, a judge's decision to pause troop deployments felt to many like a necessary, if temporary, cooling of tensions. The legal wrangling will not erase the deeper political dispute driving it. At its core is a debate about how far the federal government can go to enforce immigration policy when local officials object. It raises constitutional questions about separation of powers, the proper role of the military in domestic affairs, and the protection of civil liberties during contentious operations. Those debates are now playing out in courtrooms, in city councils, and on public streets. Looking ahead, both sides are preparing their next moves. City and state officials who challenge the deployment will maintain vigilance to ensure the ruling is enforced. The federal government, meanwhile, has signaled it will use all available legal avenues, including appeals, and has not ruled out further deployments elsewhere. The possibility that the administration might invoke extraordinary powers such as the Insurrection Act keeps the stakes high and underscores how quickly domestic policy can become a national security and constitutional flashpoint. For those watching from afar, this confrontation offers a stark illustration of how immigration policy, law enforcement, and partisan politics can collide, sometimes bringing soldiers into communities in ways long associated with crises abroad rather than disputes at home. The court's interventions have so far paused that dynamic in Illinois, but only time will tell whether the pause will become a longer-term limit on such tactics or a short-lived check overridden on appeal. In the short term, Chicagoans and Illinois residents can expect a period of heightened legal activity and public attention. Orders will be drafted, appeals filed, and decisions issued. Protesters and civil liberties lawyers will remain active at the facilities, documenting, litigating, and urging public accountability. For many observers, the central question now is whether American institutions, courts, legislatures, and civic leaders can manage this crisis without allowing force to become the first response. This episode is a reminder that in a democracy, the use of force within national borders is supposed to be tightly constrained, and that judges, for all their flaws, play a key role in testing whether that constraint is being respected. The temporary block on National Guard deployments in Illinois does not end the broader policy fight, but it does highlight that even the most forceful executive actions must pass legal and constitutional muster. For the people who live amid these tensions, The court's pause offered, if only briefly, a measure of breathing room.